Thank you very much. I don't have any slides, so you just get to look at my lovely face. And thank you very much for the opportunity to be here. It's interesting presenting this paper after the previous three, but in particular the previous two, because when I was thinking about what I wanted to talk about, I was thinking I wanted to talk a bit about the oaths of office that Susan's talked about, and then I wanted to talk about the charitable corporation and Sutton. So potentially I don't need to speak at all because my paper has been given. But it does mean I can summarise some of the points. So this paper forms part of a current book project, which has the working title Corporate Office, From Political Theology to Legal Technology. And it arises out of an Australian Research Council grant that I've been working on. Now, the book in particular seeks to engage in a critical account of the nature and exercise of corporate power, drawing upon the concepts of authority, jurisdiction, and technique. It focuses on the way in which corporate power is constitutively vicarious. That is, these entities, from the large-scale multinational, even to the small single-person company. The brakes on this before I run away. So yeah, from the large-scale multinational, even to the small single-person company, are constituted by a split and separation of the individual from the effects of their actions. Whilst raising some similar lines of inquiry, it does not think the vicarious nature of corporate power through notions of agency theory and agency costs, but through the paradigm of office, which explicitly encompasses the separation and rendering autonomous of the performance of official actions from the individual performing them. I argue that recognising and understanding the paradigm of office is important for our attempts to respond to the questions of corporate responsibility and accountability being debated today. Well, not just today, but in general. This is because the issue is not simply what purpose corporate entities are put towards or the particular interests that they serve, but the techniques of power and authority that they deploy. Now, aspects of the book at a theoretical level draw on the fields of political and economic theology, which are looking at the way in which theological concepts have been secularized and still influence our ways of thinking. And I argue these are useful in thinking about the nature of the corporation, given that key aspects of the corporate form in the Western tradition were developed by medieval canon lawyers, jurists, and theologians, and those concepts and tools they developed still influence our modes of thinking about corporate power and authority today. Now, the book is split into two parts. The first part engages in sort of the detailed theological component, and it undertakes three theological genealogies that go to show the constitutive vicariousness of corporate power and the way that corporations functions as a particular legal technique that separates assets and activities from the humans performing them. And a key aspect of that genealogy looks to the medieval development of the notion of office and an understanding of the one performing the office as independent or separate from the actions performed. And so it works through a particular notion of instrumental cause that was developed in medieval period. At the same point in time, the significant development and schematization of what we would now refer to as corporate personhood by Pope Innocent IV enabled through the technique of the persona ficta a recognition of corporate entities separate from the individuals acting as or on their behalf. Now, my argument is that critical to each of these notions is the understanding of the way in which a corporate entity can be understood as separate from the individuals who perform as animate instruments of it. And it's a term that I take up from Aristotle and Aquinas in the medieval period. So that's the first half of the book, which I'm not talking about today. The second half of the book builds on this theory of corporate office by working through key aspects of corporate law doctrine: separate legal personality, corporate acts and the rules of attribution, the duties of directors and other corporate officers, and the debates on corporate purpose. And so today I'm picking up on a certain aspect of this in terms of the historical development of the role of director as corporate officer. And this is where it clearly interacts with the previous two papers. So in particular, I seek to think the emergence of the role of director explicitly in relation to the paradigm of office rather than as agent. And what I'm interested in is the way in which the nature and effectiveness of the board of directors and corporate officers operate as techniques that produce and enact corporate power and authority. Okay, so on the history of corporate office. So as Susan has highlighted in her fabulous book, The Making of the Modern Company, and in her paper today, the role of director can be traced, at least in England, to the early modern period, a context in which, as Conal Condren has demonstrated, the nature of office was a presupposition of arguments about morality, responsibility, and the exercise of positions of power. This ethics of office involved a particular understanding of morality, of what is the correct or right thing to do, as arising from particular roles and social situations. This is not the modern view of morality, in any sort of universal notion, a Kantian categorical imperative, but rather morality is dependent on what social or institutional roles one occupies. Now, this included not only the types of officers that we remain familiar with today, presidents, prime ministers, judges, public servants, etc., but also other social roles. And Condren refers to actors, poets, philosophers as all encompassing an office. But it can also be expanded to a range of other social positions. And as Condren notes, the vocabulary of office carried with it both a positive register of rights, liberties, duty, rule, and service to the office, as well as a negative register imputing neglect, oppression, license, and tyranny in relation to a failure to appropriately carry out office. This vocabulary was used in the construction of the social expectations of roles to be performed. And as Susan has demonstrated, one of the key locations of this was in the construction of oaths of office. And Susan has obviously sort of taken us through the 17th century charter companies and the English East India Company, looking to the way these oaths shifted in the tension between the elite committee men, the merchants who were acting in their own interest, versus the generality, and that shift where the generality said, no, you need to actually take an oath of office that commits to the interests of the shareholders in general, not simply their own self-interest. Now, this is one component of the emergence of the modern company, which involved the separation of the interests of the company and the interests of the shareholders from the individuals involved in it themselves. And I would argue that this separation functioned not only at the level of shareholders, but also through the paradigm of office itself in relation to the committee men or directors. This is because what becomes moral or responsible action is not independently judged, but is judged in terms of the exercise and fulfillment of office. And at that point in time is only in a small way governed by the law. So as Susan mentioned, the significance of the oath is both that it activated a separate ecclesiastical jurisdiction, but also that it encompassed a social articulation of the nature or expectations of office. It provided a vocabulary or articulation of what was expected of the ideal officer and what could be censured for a failure of office. And in later cases, this encompassed a reference to a breach of both office and duty. Now, this is where we come to the charitable corporation and Sutton, as discussed by Steve and Nick. And there, as they noted, the role of director or committee man is articulated expressly in the vocabulary of office, and that sort of notion of the mixed office, having both a public component and a private component. And the literature on the charitable corporation and Sutton sort of works through the questions of whether directors can be likened to agents or trustees or not, and the differences, and also the challenges or the risks of reading back into 18th century jurisprudence, the 19th and 20th century concepts of agency and trust that we do. Now, in the charitable corporation and Sutton, what I found interesting is that the authority cited in the judgment establishing directors as officers was not an English one, but rather the English translation of the French jurist Daumat's systematic summary of Roman civil and public law. And in the context of that text, whilst noting that the level of care and diligence of a director is the same as that of an agent or factor, the obligations of directors are categorized not in relation to roles where there is an agreement or covenant governing them, such as partnerships or other sort of agency type relationships, but circumstances where obligations arise from the taking on of a particular role, including that of tutor or guardian or curator. And specifically in the categorization of the latter, that directors or administrators of corporate bodies are considered. Now, this gives, I think, some further grounding to the arguments that Lord Hardwicke should not be read as substantiating that directors were either agents or trustees, but rather recognises the specific nature of corporate office as an independent category, even if understood by analogy to agency or trust laws. Okay, so what follows from this understanding of the director as fulfilling a notion of office? In charitable corporation, it encompassed liability for fraud, misfeasance, and breach of trust, which can be articulated explicitly as a notion of a breach of office. The judgment distinguished between types of actions that were a breach of trust and actions that were considered neglect. The former related to failures by directors to follow the requirements of the charter and bylaws, as well as fraudulent signing off of certain pledges and loans. The latter, however, were distinguished, and these were actions conducted within the powers of office, including repealing bylaws, appointing certain individuals, issuing notes and bonds, etc. But the issue was that so the issue was not that they had failed to exercise powers granted to them in accordance with the charter, but rather the way in which they had exercised those powers, giving rise to the potential for fraud. And so what's articulated is both the requirements of office in terms of duties and obligations, as well as what constitutes failure or a breach of office, the latter encompassing both a failure to perform required actions, as well as a misuse of those powers granted to directors. Now, this idea of thinking about the director as office sort of aligns with the notion that the director is a sui generis role that exercises the authority and power of the corporation directly. So, thinking a little bit conceptually in the few minutes that I have left, what are the potential effects of this understanding? Well, at one level, it can link to a sense of thinking about the corporation as a separate legal person or a separate legal entity in a substantive notion, and that sort of broadening of, what are the interests of the corporation. So we can link it to stakeholder accounts, broader accounts of corporate purpose, and the like. We could also potentially take up, and it'd be interesting to see where Nick and Steve's work goes, this idea that the director is a mixed office, and thinking through what is the public responsibilities of a director in addition to their private responsibilities. So in those instances, the construction of the director in terms of office is about articulating a form of responsibility. At the same time, however, the paradigm of office itself also highlights the way in which the corporate form and bureaucratic forms of governance more generally can produce irresponsibility. This is because one of the effects of understanding moral, ethical, or legal conduct in terms of the fulfillment of duties of office is that responsibility becomes only the fulfillment of office. Now, this point links to my larger arguments about the way in which corporate power is constitutively vicarious. Vicarious because those exercising corporate power do so on behalf of the corporation, not themselves, but constitutive because the corporate form is premised on the ability for the power to be exercised in that fashion. As such, directors, as well as other corporate officers, can be considered animate instruments of the corporation acting as or on its behalf. Now, this gives rise to the question of what it means to say that directors are acting responsibly in their fulfillment of office, and, for example, acting in the best interest of the company, which often they are the ones that get to determine what the best interests are, whilst at the same time potentially allowing the corporation or causing the corporation to engage in actions that produce significant harm. So, the most obvious scenario is where certain activities of the corporation will produce significant profit or shareholder value, but generate a whole raft of externalities at the same point in time. If the responsibility of the director is to fulfill their office, but the office is articulated only in terms of a narrow scope of interests, then the director will not be responsible for harms produced outside that scope. That is, in this paradigm, one's responsibility is separated from the individual. Whilst calls for addressing stakeholder interests, a redefining of the purpose of the corporation, or broader notion of what the best interest of the company includes, seeks to address this problem by adjusting the ends that the office is put towards, they do not address the underlying nature of the paradigm of office itself, which, in the very process of articulating what lies within the responsibility of the director, also excludes responsibility for other harms the conduct may cause. Furthermore, directors are incentivized to focus on taking actions that will minimize the chance that they will be liable for a breach of office, rather than necessarily taking responsibility for the effects of the fulfillment of office. And such is a point raised by Lord Hardwicke, who noted that there needed to be caution in holding directors too liable for events that happen, because if so, nobody would accept the direction of corporate affairs. And whilst needing to prevent the frauds of dishonest men, there was also the need to not make it unsafe or too perilous for honest men to accept offices of trust by making them liable to losses in the execution of them. And so what I'm trying to think through, and I'm out of time, is the tension between the use of office as a mode of responsibility, whilst at the same time potentially producing a mode of irresponsibility by limiting responsibility only to the conduct of office. Thank you.